Good afternoon, ladies and gentlemen. I know what many of you are thinking. After you have listened to Professor Mukandawire this morning, you are thinking, if that is the picture with respect to regional integration in Africa, why bother to talk about that topic? Well, William and I are going to tell you why. And one of the answers you will find in this particular example just mentioned by Henry, and the implication of that advice that Kenya should litigate against the EU in Geneva, if that is replicated, if that is repeated with respect to the honey, the government in Lusaka has got no place to go to, no forum, no court to go to in order to litigate on that matter, on the honey matter. It will have to travel all the way to Geneva and sue South Africa under the SPS agreement of the WTO. That is one of the reasons why we want to talk about this topic. Now, I've not met Professor Mukandawire before. I've heard about him. I guess he and I will differ about certain things unless we've got a good bottle of Shiraz between us. Provision in this part of the world is not a problem. But I do agree with many of the things that he has said. And one of them is that dictators don't form federations. The metaphor is very important. That metaphor says dictators consider themselves above the law. Which law? All relevant law. Domestic, national, regional, even those, and in particular those, where they have concluded, where they have participated in the conclusion of legal instruments. So the notion that the rule of law should be part and parcel of our regional integration exercise, as Trudy hinted this morning, is based not on the fact that we want to be better citizens only. Nothing wrong with that. It is also based on a very functional approach to the mode for interstate cooperation when you do business across borders. That is what we will want to argue. And this is related to the bigger topic raised by Trudy this morning. The question when she asked, is rules-based governance, rules-based integration, and by the way, it has implications what you do domestically, are they related to her topic, her question about the model for 21st century regional integration in our part of the world? So I hope I've justified my presence here, at least in principle. Why discussing this topic? The first reason is because there are states involved in the enterprise of regional integration. And as Dan has hinted, and I want to return to that, states enjoy sovereignty. And in our part of the world, the weaker the states are, the more sovereign they tend to become. Sovereignty, as a technical legal concept, is actually a feature of states, not of governments. That difference is often lost. But let's look at some of the manifestations of invoking sovereignty and its impact on regional integration. Dan has pointed out, and he's right, that one of the biggest problems around being sovereign is that the consequences of regional integration, which result in institutions exercising certain powers, and those institutions are courts and regional tribunals, if they do what you have empowered them to do by creating them through an international agreement, the acceptance of the consequences of the rules-based unfolding of the enterprise will be challenged by invoking sovereignty. Now, if that is true, there can never be any international law. Sovereignty does not allow a state, a government, to invoke its national constitution or national laws as a justification for not complying with its obligations. It's an act of sovereignty to conclude an international agreement. So In theory, we can say, consider these things before you sign up. Now, what Professor Murakami has pointed out to us this morning, and I'm interpreting what you are implying. If you don't agree, please correct me immediately. But he has alerted us to the fact that weak states and states with particular domestic problems, including weaknesses around the sources of public revenue on which they are dependent, that those states, and that's the irony, may indeed sign up and become active members of regional integration arrangements, but that when it comes to the implementation of obligations, then weaknesses, original weaknesses or subsequent developments are being invoked as justifications for not complying. Now that confronts us with a problem that cannot be solved. International law, as a matter of fact, no law, unless you can plead insanity on a particular moment, and insanity is not a defense for states. No law can function on the basis that subsequent consequences permit a derogation from obligations. So we are confronted with an obligation here, and it has an implication for our designs of our regional integration enterprises. In SADC, for example, the implementation model is a highly decentralized one. If you look at the Finance and Investment Protocol, for example, you will see that the obligations are formulated as what the nation states, the members, must go and do in order to give effect to their obligations. It's a decentralized model. That in itself is problematical. Now, the other reasons I would like to offer for why this discussion is still relevant is that third bullet, states trade. That's not quite true. It's not really states, governments which trade, but at least they conclude the agreements in terms of which trade takes place. So, shorthand, I say there, states trade and they deal with mosquitoes across borders. Now, why invoking the poor mosquito? It's because sovereignty has three notions. Or a state must have territory, government, and people. And the government exercises jurisdiction over all its territory and the goods and the people and whatever moves across borders. Mosquitoes didn't read the script. So, states are, by necessity, by the nature of the world that we live in, forced to interact with each other in order to deal with those many, many problems that do not respect historical boundaries. Whether they are diseases or environmental decay or trade, the state has to make peace with this reality. And the instrument for making peace is called international law. The treaties that we conclude about whatever topic we are dealing with, including regional integration. Now, of course, I must immediately qualify this enthusiastic case for the law by saying that the law is not an end in itself. It's being agreed, it's being created, it's being negotiated. And that process of negotiating legal obligations that subsequently will confront us in the face with a call to be respected and implemented is part of our challenge. Right now, when we negotiate the tripartite and soon the continental FTA, these very same questions will remain on the agenda. So using the law, using legal instruments, treaties, and regional institutions as instruments for promoting cooperation, growth, poverty alleviation, trade, whatever, between nations, those factors are a given. And our challenge, having listened to this morning's introductory paper, is how to reconcile the the weaknesses and the tensions that may lurk in the present conditions. But we can't move away from that. The irony is that the very same benefits that are being invoked as a consequence of flowing from sovereignty are also at the same time the challenges, because you have to respect the consequences of your own creatures. Now, other reasons why we have to deal with how we implement, respect international agreements, regional agreements, and how we resolve the conflicts that arise will simply flow from some of these other reminders that the founding instruments of SADC and so on want exactly to do that. Things have to move on. We have to find answers to conflicts. Now, Paul Kalenga invoked the metaphor of the marriage this morning, but that's not a good one. There are no marriage counselors for regional integration, not that I know of. If they knock on your door and they offer their services, don't buy it. The counselor that we have comes in the form of either consultations, or if that fails, we have to move on to a forum where there can be final certainty as to the difference in opinion on the meaning of the contract or the legal instrument, so that business can move on. If you and I enter into a contract today about buying a bicycle or a motor car or whatever, and we've got a dispute, or our business wants to sell the wine being produced here in Johannesburg, and there's a contractual dispute, we have to resolve it. We go to a court of law. If we can't resolve it through consultations, that brings certainty. Things move on. Why is it in principle different? This need to have things moved on, certainty, predictability, when the same wine is being sold in Windhoek or in Lusaka. I'll come to the honey later. Now, the trade facilitation point is also important. And then that last one is, Trudy hinted to that one as well. We happen to believe in the rule of law as a good guiding star. As a matter of fact, I'm only a lawyer, and therefore I can excuse myself if I don't move into all the philosophical debates that we heard earlier this morning. But I read an opening paragraph in a World Bank report the other day, and this particular report is about trade facilitation. It quotes a famous international economist recognized by the fact that the Nobel Prize was awarded to him, and he apparently once said, when asked what is the most fundamental rule in promoting development, getting these things done, he said the rule of law. I will not quarrel with that authority in the present company. There's a quick reminder here of what some of the legal instruments say. Remember my point, one of the reasons why we have to deal with dispute resolution is because the founding instruments of our regional institutions want us to do so. There's a quick reminder just from the SADC Treaty and the SADC Trade Protocol, and we don't have to analyze that, but just as evidence being invoked there. The next question I think is also important. What are these disputes about that we are discussing? Now, William is going to discuss a very, very interesting case which involves private parties invoking regional trade instruments. There are some of these very same cases now before national courts inter alia in Namibia. This is a trend that we want to mention to you. We can discuss it later. There will be an opportunity tomorrow maybe to come back to some of these things. But I want to make the point that the disputes that flow from implementing regional agreements are not confined, limited to interstate disputes. The implementation of a regional legal instrument domestically, someone talked this morning here about domestication. Now that is not something that is actively being pursued. My point is we don't have to domesticate trade agreements in order to implement them. We must take our domestic regulatory and legislative instruments and amend them or change them or create new ones so that we can give effect to those. If we conclude an agreement about liberalizing trade and it's about tariffs, you don't domesticate the SADC trade protocol in order to give effect to it. You simply change your tariff book. But be that as it may, the point here is that our reaction to the questions around, is it necessary to have dispute resolution as part of the regional integration exercise, involves domestic, national, as well as interstate elements. Now, what is our record in SADC? Let's look at SADC. William is going to talk about interesting developments, inconclusive but interesting developments in COMESA. In the EAC, there are from time to time interesting cases, but it seems to me they are about high-level political matters. In SADC, one of the main instruments right from the beginning provided for in the treaty was the SADC Tribunal. It was eventually created after a long delay. It started exercising jurisdiction, starting to work in 2005. It existed for 5 years, and in those 5 years has heard about 15 cases, if I remember correctly, of which all but one was about secretariat officials being unhappy with the labor conditions or the disciplines or the non-renewal of contracts running to the SADC Tribunal. Nothing wrong with that, but what does it tell us? It tells us, as we know, governments in our part of the world don't litigate against each other. The only exception is when it's a border issue. Now, what happened to the SADC Tribunal? We all know it got disbanded the moment it had the audacity to rule against one of the member states. A citizen of Zimbabwe brought an application for violation of two provisions in the SADC Treaty about democracy and human rights. The court, the tribunal, ruled in its favor. But then, of course, and that's another flaw in the design and a point I want to emphasize, if we take this challenge seriously, then we have to design and think through legal instruments that will make it effective. Now, rulings by the tribunal, the SADC Tribunal, for their implementation dependent on council decisions. Who are council? Well, the member states. How do they take decisions? By consensus. So, now, I want to pause a little and express my sympathy for Zimbabwe with respect to the Campbell case. The Campbell case should not have ended up before the SADC Tribunal. The SADC Tribunal, in my book, was never designed to be a human rights court. It doesn't solve my problem that the many trade disputes that do exist in SADC have never ended up before that tribunal. We'll come to that chapter. But my concern here is that the wrong case, the wrong facts became the first case before the SADC Tribunal involving a member state. That doesn't mean that I'm again opposed to the effective protection of human rights. But where I want to agree again with our opening speaker this morning, when he said something to the effect that domestic social and political conditions must be in place before they can form the platform for stimulating the very same countries into entering into regional agreements. Did I understand you correctly? The same applies to this particular problem. If a particular country, a state, doesn't allow for the protection, effective protection of human rights in its own domestic legal system, why would it sign up to a regional or international court or the African Court for Protection of Human Rights to give effect to something which it is not prepared to protect at home? The fact that many governments do sign up calls for a cynical reaction and drawing our attention to the weakness in the design. But the tension, if you're serious about human rights, it's not very difficult to draft a Bill of Rights clause and to put it in your constitution. And I want to say that the same link between domestic factors which give legitimacy to what states do between themselves, we must keep in mind, because the effectiveness of the law and of legal instruments ultimately depend also on these linkages. So I've made 2 points now. If you want these effective legal regional intergovernmental instruments, design them soundly, but then of course you must believe in what you're doing. You must indeed create instruments which you believe will promote the exercise. Secondly, don't be over-ambitious, as Paul reminded us this morning, or sign up to legal instruments without an understanding of the consequence of not respecting them. It is true, Articles 4 and Article 6 of the SADC Treaty talks about respecting human rights and democracy. And it is true that it didn't happen. But was it also correct, legally sound for the SADC Tribunal to allow standing to individuals to complain about that particular thing? On that we will differ. Be it as it may, the tribunal was very bold. It gave that judgment, and it meant the end of the SADC Tribunal. Since that time, there are efforts to revive that tribunal. All indications now are, and I've got it from officials involved, that the new SADC Tribunal will be limited to interstate disputes, full stop. That might mean no disputes. Is effective dispute resolution possible in our regional integration enterprises? I would think so. I would like to argue so. But I would also like to argue that if you take this bullet here, that one there about trade facilitation, non-tariff barriers in the Zambian honey example, why is it not possible for our governments, what would be the attack? What would be the attack on sovereignty to refer the Zambian honey issue to a technical forum, to a court, to a regional instrument, a regional tribunal, and to have a conclusive judgment on the applicable law and things move on? It is not an attack on the sovereignty of the state. As a matter of fact, a government can then use that, it can blame the tribunal. This point is often argued in discussions about the legitimacy of the WTO, where, by the way, we've accepted the same obligations. If tomorrow Brazil would bring a case, as they threatened last year, against South Africa with respect to the anti-dumping duties on imposing chickens, and they can't resolve it through consultation, there's no way that you can turn up or not turn up in Geneva, plead sovereignty, and do not appear before the dispute settlement panel and appellate body of the WTO. There we have accepted these obligations. I'm trying to argue that there are practical advantages in sound dispute settlement mechanisms for moving the enterprise of regional integration forward in a predictable manner, in a legally certain manner, and in order to recognize that trade is the business in which private parties engage, most of the time, not governments. Our governments are not prepared to take up the cases of their nationals before regional courts. We are not going to see that. So what will hopefully come in the place of that? We have to think about ad hoc mechanisms. We'll have to think about domestic legal disputes. By the way, the courts of this land has ruled a number of times, the national courts, against the government of Zimbabwe. It has even issued an order to sell the property of the Zimbabwean government right here in the Camps Bay area in order to satisfy a claim by a private party. I'm not aware of the high commissioners between the two countries being recalled as a consequence of that. So my final plea here, ladies and gentlemen, is that the exercise of regional integration, this enterprise, needs support through legal certainty, predictability, and signals which will invite investors, which will invite those who do business to do it, to continue to do it in a manner which will be optimal, Trudy often reminds me, when she calls me into her office and pontificates about what has to be done, that business is smart. They will find ways around legal problems. It may be that the consequence will not be so nice to all of us. Someone has to pay the price. The consumers will pay the price. But the benefits of legal certainty, predictability, moving the business on in a rules-based manner is indeed part of the credo at tralac on this particular chapter. Now, there are possibilities offered there. That third last bullet talks about Annex 6 of the SADC Trade Protocol. The SADC Trade Protocol has an annex. It has an annex. It has been dormant for years. If that annex, which provides for panel procedures, could be activated as it is written at this moment, it could be a very, very useful instrument for settling disputes, for settling the honey case. So why is it not? Why has it been dormant for so long? Now it's probably too late, because the new debate on the SADC Tribunal has now thrown into the pot of unacceptability everything that smells of dispute settlement, I'm afraid. That's very unfortunate. It need not be like that. Let's distinguish between high politics and sensitivity matters and the day-to-day business of regional integration and moving on. So what to do? I think we can't turn back the clock. I've listened carefully this morning about those original debates and the original designs and the Pan-Africanism. And I must admit that I think we are permanently spoiled, our governments, by the lure, by the temptation of sovereignty. We can't turn back the clock. If you can't turn back the clock, it doesn't mean we can't have relevant debates and new issues. But I have very little faith that when the continental FTA, Continental Free Trade Area debate negotiations, not debate, negotiations, start next year, that they will be inspired by solidarity, Pan-Africanism, etc. No, they will be inspired by the typical thinking of modern states on how to promote offensive interests and defend defensive ones in trade negotiations, at least when it is about goods. And that is why Trudy's call that we have to think outside the box and identify those trade issues that we want to negotiate about, which are addressing our problems, trade facilitation problems, transport problems, honey problems. Why don't we prioritize them? Why don't we consolidate what we have in the FTAs already when it comes to trade and goods? We'll discuss this tomorrow, but there are new ways of looking at the agenda of negotiations, trade negotiations. But I firmly believe that what we will see in the continental FTA, just think of it, Nigerian delegation, #1 economy in Africa at the moment. By the way, this is an economy that claims that one of the reasons why it is not prepared to sign the EPA is it will lose tariff revenue. The biggest economy in Africa will lose tariff revenue and therefore cannot sign an EPA. I missed something here. But if we have Nigeria in the same room, and we have Pretoria, and we have Kenya, and I don't know whether the Rex will be there, but the chemistry that will be in there will be that of protecting national interests, revenue, and national development programs and plans. Nothing wrong with that, nothing wrong with that. That is how these sovereign states do it. Now, of course, we would like, and us would like, I think, to plead for those factors which makes regional integration a very important option for our development plans. The link between our national development plans and our regional development, those links are part and parcel of the justification for these exercises. No country in Africa can prosper in isolation. And if that INGA electricity project comes off the ground in a manner that is inspired by, indeed, an approach or a philosophy to allow the potential of that scheme to benefit all that can benefit, it is then based on sound self-interest, but also on regional and joint interest. It can be worked out. By the way, that particular factory, which was mentioned here this morning, which is now tempting this government to redirect the electricity stream to a private aluminium plant, arrived there with the blessings of that government. It is not illegally there. It has a passport for its commercial presence. How it was obtained, I don't know, I have suspicions. Okay. Ladies and gentlemen, to conclude, I want to repeat the link with Trudy's speech of this morning, that it makes sense, I would like to argue at least, to consider the rules-based context for designing regional integration and implementing regional integration agreements. But I would like to stop to conclude by referring you to this one, third last point there. I call it the danger of retaliation. In SADC, there's a detailed trade protocol. It provides for all the typical disciplines, from tariff liberalization, NTBs, SPS, TBTs, the rules of origin, right through trade remedies and dispute settlement. Now, the trade remedies is an interesting one because it's a particular manifestation of giving effect to a rules-based system. In the SADC trade protocol, you'll find provisions on anti-dumping, countervailing, and safeguards. They've never been invoked. Why not? Why is Zimbabwe and some other members, Paul can help me here with the detail, but he mentioned this morning that in SADC, we've got retrogression, we've got backward moving, we've got examples where governments start to put tariffs in place on goods which are violations of their schedules. They are violating the agreement. Well, if that continues, the fear of retaliation becomes real. Once we are into the business of retaliation against unlawful acts by particular member states, we are in a downward spiral. And that one is really unpredictable. That one really undermines regional integration. Thank you, Henry, for your patience.